Good morning. Representative Freeman, House Bill 55.
Thank you, Mr. Chairman. Representative Marcel is co-authoring this bill with me, so she wanted to come sit at the table as well. So I think it was just added, so you may not see it yet, but she wanted to come testify with me. So House Bill 55 simply removes the notarization requirement for a temporary restraining order when someone is seeking a petition from domestic abuse, sexual assault, dating violence, or stalking. As many of you know, domestic violence is devastating and a pervasive issue in Louisiana with literally deadly consequences. We consistently lead the nation of women being murdered by men. And for me, this summer, it became very personal. Some of you know, and some of you don't know, but my cousin, Lowry Walters, was murdered by her abuser in July in Youngsville, Louisiana. So I've always wanted to fight on behalf of women, but of course it became way more personal for me when I lost a family member to domestic violence. So in working with the New Orleans Family Justice Center and the Coalition Against Domestic Violence and talking to them over the past several months, it came to my attention through their work that many of the victims of domestic violence, when they go to get their restraining order, it's a three-step process. So this bill takes it into a one-step process. Currently, if you are someone who needs to seek temporary restraining order, you have to go to the clerk's office, and then you have to go to a notary, and then you have to come back to the clerk's office. So it's a three-step process. If you are in a dangerous situation, taking that first step is hard enough. And for the women who are in domestic violence relationships, sometimes just that one decision for them to show up to the first spot is humongous, because many of them are controlled by their abusers and sometimes not even aware of how controlled they are. So this bill, to me, makes a protective order an easier thing for someone to get, and it's temporary. They still have to have the hearing. I know there's some concern from some committee members that they wouldn't be penalized for perjury, but they will be penalized for perjury. So it's just taking an affirmation at the clerk's office instead of requiring an affidavit. As y'all know, I'm not an attorney, but they're still put to the test of telling the truth. And in my opinion, if someone was going to lie about this, they would lie to a notary too. So I just really want to look at simplifying the process for the women of our state. I'll remind you, we're literally in the top 5, and it's very disturbing to me that we continue to watch women being murdered in our state. And if we can do anything to help them, this is why I'm sponsoring this bill. And I know Representative Marcel wanted to add some pieces, and we have some other people here to testify and talk to you about the bill.
Thank you. Representative Marcel.
Thank you, Chairman and members of this committee. And I first want to start out by thanking Aimee Freeman, Representative Freeman, for bringing this bill. I think it's important that we remove any barriers as it relates to women who are suffering from domestic violence. Some of you may know, some of my former representatives, and when I came in, they've probably heard my story that I am a victim of domestic violence. Although I did not seek a protective order, in my case, I was left for dead in my home. So I started to work with a lot of women who suffered from domestic violence. I've worked with a lot of organizations. I've seen some of the barriers that they're faced with, and this is one of them. On the flip side of that, I'm also a notary public. And so I've heard people say, well, I prefer them come in and we'll have to explain to them that if they sign this, they're committing perjury, and that just doesn't happen if you're a notary public. In fact, I'm barred from giving legal advice as a notary. All I'm doing is attesting that that is the person on the license that's signing the document. Nobody does all of that. And so if we're going to be consistent with doing the things to help women who are suffering from domestic violence, we want to pass common sense legislation. And by the way, this is not rocket science. They're doing it in other states. An affirmation versus an affidavit. So I just don't know what barriers that would be to stopping this legislation, but if there is any, I would like to work with Representative Freeman and any of you who have issues with this legislation. We're ranked number 5, as she has said. We need to do everything within our power to protect women in the state of Louisiana, because today it may be someone on television, and tomorrow it may be one of your family members, it may be your daughter, your sister, some loved one that you know, and then it becomes personal. It's very personal to me, and I would love to have you all to support this legislation. I'll be happy to answer any questions if you have them.
Thank you. Thank both of y'all for being here, and so sorry for your loss, Representative Freeman, and thank you for sharing that story, your personal situation. That definitely puts some more light on these kind of things, and they do hit very close to home. Representative Johnson for a question.
Yeah, thank you. A couple of things. First of all, thank you for having the foresight to do this, because clearly it would remove barriers to get protection for victims. I certainly want to share the feelings of everyone here of our sorrow for your loss. I thought you were a lawyer. So
I know a lot of people think that.
I don't know if that's a compliment or not, but I think when your
It
case,
depends on the day.
in your case, it's
That's
very
a
much
compliment in this committee.
But I want to say thank you for bringing this bill and point out, I know we're thinking primarily of women, but it's anyone that's a victim of domestic
Absolutely.
abuse.
Correct.
And so I think it's even more of a significant thing. So thank you. I'm certainly going to support it, and appreciate you bringing this kind of proactive type thing to take something very simple and make it a whole lot easier, because trying to find a notary to buy a car is a major deal for somebody. And if they're in an emotional situation, where do you go to get a notary? Do I have to get a notary? Is somebody going to see me go get a notary? And I could see where you have the same penalty if you don't tell the truth. The only question might be identity, but I would much rather save 10 people than have a rare occasion where something else happens. So thank you for that, and I appreciate you.
And just let me add that this is not the case in all of the parishes. East Baton Rouge doesn't do it that way, and many of the other parishes, I think up in Monroe or somewhere, they don't do it either. This is certain parishes that require you to do that. So we don't have that issue in East Baton Rouge Parish. They are done right there on the site, but that's not the case everywhere. So I think it needs to be consistent across the state so that all the women would have the same protection. And I would think that particularly in rural areas where there aren't many notaries, that would even be a greater challenge to go and find a notary, particularly with the pandemic.
Right.
That was going on. There was a lot of issues with that as well. So I just want to add that all parishes don't do that. But the ones that do, we need to clarify the language in our legislation to fix that.
Thank you.
And I did speak to the Clerks Association this morning, and they weren't aware of some of the parishes where this wasn't working, and they had no issues with this legislation, but they did want to find out where the problems were existing.
Right. Thank you very much.
I'd like to add, too, that the pandemic was not the reason for this, because when I investigated this with the domestic violence group and New Orleans Family Justice Center, at first they thought it was because of the pandemic that they were running into this problem, but once they started really talking to survivors, this has been a problem pre-pandemic. So it's not a pandemic-related issue for the survivors.
Thank you. Representative Marino for a question.
Yeah, thank you. Thank you. So when I'm reading what you're trying, I see the perjury provision, which you're putting in there, but I might have a suggestion for you. Instead of actually writing out any false statement contained in the petition shall constitute perjury and shall be punishable by a fine of, I would suggest that you just reference the perjury statute. So if the perjury statute changes, you don't have to come backwards and find it again in your law. And your law actually has a different penalty than the perjury statute. The perjury statute, which is 14.123, actually says they're much bigger fines than $1,000 if a judge wants to impose a fine. So you're redefining the sentence in it. It may be better to just reference, to say that that this statement or this affirmation is subject to the provisions of revised statute 14:123, and that way, like I said, you won't have to change this if the perjury statute ever changes. And there's also one other thing in the perjury statute that's the other part about what your bill is listing. It just says any false statement shall constitute perjury, but for perjury it has to be a false statement which is under sanction of oath or equivalent affirmation, so this would cover it. But it says and must relate to a matter of material material to the issue of or question in controversy. So I don't know that any statement constitutes perjury. It has to be something that's material to the issue or so.
Yeah. Thank you, Representative Marino. And you are an attorney that I really respect. So I would look forward to working with you to get that language fixed. I'm just finding out from that the reference was to Title 46 for the perjury definition from the domestic abuse.
Okay.
So that's where it came from. But if it makes it more clear to reference 14.123, I've made a note and we could amend appropriately.
Yeah, it should just reference one of them, but the one for in 14.123 has perjury and it breaks it down. Talks about in trials, and then there's a section that says section C3 says when committed in all other cases. When committed in any civil action, administrative proceeding, and so I think that fits. But one way or the other, I think you should reference it to a statute and not define it.
Thank you.
And I'll just point out right now the current law for the provision in the Children's Code, Article 1568, and as well as 462134. The penalty provision, I think, is different than in the specific perjury provision, and I don't know, why. They probably weren't really thinking about that at that time, but it would be, I think, helpful if we kind of, codify it or make it consistent. I don't, but I don't know when this was originally adopted, but thanks for pointing that out.
Can I ask one more question?
Sure, go ahead.
Okay, so the other question is, you're leaving an affidavit as the possible way to do it in the first section under temporary restraining order, affidavit or affirmation, but then you'll take affidavit out in the other places. Why is that different? Somebody behind
Which
you.
line? Which line? Oh, okay.
So in the first part, you still leave in the ability to do an affidavit, temporary, Article 3603, temporary restraining order, affidavit or affirmation. So you're inserting you're leaving affidavit and saying or by affirmation in Article 3603, but then in 1568 you're striking affidavit. It's not an or there. I just wondered why. And then in the last one too.
Annie pointed out, because that provision, 3603, the Code of Civil Procedure, deals with all restraining orders.
Okay.
You know, and not specifically to the domestic abuse restraining orders. Hey, good morning.
And this is Mariah Winsky with you. I'll let you state your name that I've been working with.
Hi, I'm Mariah Wineski I'm the director of the Louisiana Coalition Against Domestic Violence, and I was just popping up here to answer that question. So
Right.
I also have other testimony, but I'll wait until
Sure.
the questions.
Did we answer it right?
Yes,
Okay.
that's correct. So
Thank
that
you.
that 3603, that's because the restraining orders that are not having to do with domestic abuse, sexual assault, dating violence, or stalking would still have the affidavit. So this one only removes it for those particular orders.
All right, thank you. We have Representative Jenkins for a question.
I thought I had it until Marino started asking questions down there. But seriously now, I want to commend you for bringing the bill. I think it's something that we certainly need to pursue and make sure that people have an opportunity to not be deterred because of a lot of formalities that may be involved. But at the same time, we want to make sure that no one is abusing the process, because when these allegations are made, it can do a lot to a person's career, their family, their name, everything. So we just want to be certain, and I would like to make sure that we follow up on whatever we need to do to make sure that these provisions are in here if someone abuses this process. So I don't know, just hearing some of this today, which direction that's going to go in, but I'm hearing from you that you will look into it and make sure there's some uniformity there, and it will contain some provision that if someone falsely accuses someone, or if there's some scenario where someone uses this process to abuse in an abusive manner, there needs to be some consequence for it.
Yeah, and I agree with you, Representative Jenkins, that there should be a consequence for that. I know the Family Justice Center and Mariah can speak to how often that happens. I don't want to stop protecting these women based on the few that
No, I agree.
that are
I agree.
falsely accusing, and I do know that it happens, but I think sometimes that conversation outweighs the survivors, and I'm here on behalf of the survivors.
Right, and as we,
And those who are deceased, like my cousin.
Yeah, and I agree now. And as we initially said, anybody, regardless of their gender, can be a victim of domestic abuse. So I'm not just speaking from a gender term. Anyone who abuses this process, there needs to be some consequence for abusing the process. We don't want to deter anyone from being able to do it, but we certainly don't want anyone to feel like they can do that and literally ruin somebody's life just by making an accusation. And if you don't have some consequence in it, it could be, some concern there. I look forward to supporting this. But I just want to make sure that we cover some of the ground that I just heard up here a few minutes ago. And then once again, now this is more of a civil type matter anyway. This is not something that's going to be used to go and arrest somebody. It's temporary restraining order until some kind of full-blown hearing can be held at a later time. Is that right?
That's correct.
All right. So I commend you for bringing the bill. I look forward to supporting it. Hopefully we can, tweak and define, some of the things that we just heard this morning. But I certainly think there's a place for this and there's a need for it. And just like you said, to me, if someone is going to do the wrong thing, whether it's before a notary or affirmation, if they got the wrong spirit about what they're doing, I don't think a notary is going to stand in the way of doing that. So at any rate, I look forward to supporting you on this, Representative, okay?
Okay. Thank you, Representative Jenkins.
Thank you, Mr. Chairman.
Thank you. Representative Jefferson for a question.
Thank you, Mr. Chairman. Again, let me join everyone in thanking you for bringing this. And you mentioned something in your remarks. The first step is the most difficult or the hardest in many instances, and I agree. My question is, I've had a lot of instances where men and women who've, tried to get a TRO or what have you, and the form that we have right now can be a bit intimidating, if you will. So my question to you, as it relates to the affirmation, the affidavit, etc., are we going to look at the form per se? Okay, all right, that was my question.
Yeah, and I'll let Mariah answer that question.
Okay.
Yes, sir. So we would work with so right now the Louisiana Protective Order Registry creates the forms, and anytime that there is a change to the protective order process or statute, then they revise the forms accordingly. And so if this were enacted, they would revise the forms to include and facilitate that affirmation.
Thank you, because I've had a lot of situations where that form is very, very intimidating. So thank you also again. Thank you, Mr. Chairman.
Thank you. Representative Muscarella for a question.
Thank you, Mr. Chairman. I don't know the answer to this, but I'm pretty sure that deputy clerks for the clerks of courts have the ability to notarize documents. I can follow up and make sure of that. I called my clerk to kind of see how that works. Are you familiar with that and understand that process?
Yes, sir. They do have they do have that ability in some parishes. They do not provide the notarization for these orders in every parish.
Why not?
So I do not know.
Well, maybe we should make them do that.
So there already is a in the statute. There is already, I think it's 3603.1. It already says that the clerk of court shall make the forms available for making application for protective orders, provide clerical assistance to the petitioner when necessary, provide the necessary forms, and provide the services of a notary where available for completion of the petition. So there is already a provision that indicates that they can and ought to be providing those notary services. In some places, and I think there are some advocates here from areas where that doesn't happen that can speak more to how it actually goes.
I'd be curious
there.
to know why that, because I mean, it seems like it's pretty textbook in my parish that you go in, the deputy clerks are able to notarize your, hey, you're Jane Doe, okay, we can authorize and approve that and sign the document. Maybe we should look at making sure that other parishes are following suit on that.
Yes, we have attempted that. Now, we're not legislators, we're just advocates, right? So we've attempted to have some conversations there, but I think it's different in every community. But the issue is that it's not consistent, right? So when we surveyed our member programs, which are the domestic violence advocacy and shelter organizations across the state, and they're the folks who are kind of helping walk victims through this process of getting the restraining order. And there were at least 9 parishes where there are no notary services available at the clerk of court.
So here's my question, because I'm trying to visualize it. A person is being harassed by their spouse. They go to the clerk, they get the form. They sign the paper, they fill out the paperwork. Under this bill, they will just file it. They don't have to prove any identification to say I am. What if, I know this is kind of far-fetched, but what if I go and make up a statement, say, I'm Aimee Freeman, and file it? And just, it goes into the record, and Aimee doesn't even know that I did this. There's no cameras to see I went in the office. People file fraudulent documents all the time.
And if they did that, they would be committing perjury.
Well, how do we prove it, though? How do we prove that I did that on behalf of Aimee? I just signed Aimee's name. I know it's kind of, but we need to be able to prove, like as an attorney, I sign a document, the consequences will come to me if I screw up. But if some random person just goes and does a fake document, we can't prove that she or he did it. That's my concern. Look, I want to support the bill. But I think there's a way to do this where we can all come together and kind of make it more efficient, and we can also prove to that the identity of the person that's signing the document. I think that's the only thing I'm concerned about is the idea of the person signing the document, making sure that it's them. So
Could they still show their ID
When they file?
when they file?
Yeah,
I don't know if that happens now.
See, that's what I don't know, because I'm trying to visualize it. Is that, I don't know. Is it?
They do provide, my understanding is at the clerk, and again, it might vary place to place, but they provide documentation and identification as they're filing.
But I think your bill is trying to make everything more consistent, and we're guessing now on what parishes do. We know Orleans may do it a lot different than Tangipahoa. So I think the bill needs to be a bill that makes it clear for everybody. where we're not guessing if, Jefferson Parish doesn't take ID, but my parish does. I think we're trying to achieve one goal.
So
So let's make it a law that, and I can get with you, Aimee, and give you my thoughts, but
Okay.
I think we're all going in the same direction. We just need to, knowing the process and how it's done, I'm just visualizing, going to the clerk, filing it, no ID, that's just what we're trying to do.
Yeah, and I would just
And
add.
I would work with you on that, Representative Mescal.
Yeah, I would just add, look, we don't want to throw the baby. I think in the committee doesn't have. I don't think we have any issues. We're supportive of it. It's just to me that Representative Muscarella did raise that issue. Now with the ID, you typically when you're there present, you're probably asking for them to notarize this, but I guess without having to be there, you wouldn't have to. So, but also I don't want to try to amend something on the fly, which creates bigger problems because we have the issues of the victims of domestic abuse, and maybe they don't want it to be a public record. I think there's some specific provisions in the Domestic Abuse Protective Act that deal with if they don't want to provide where they are. Am I correct? So that the abuser can't go and find them, and if they don't want to publish where they are, so that they can be protected. So that that's one of the things. And I don't want to just try to do something on the fly, but I think I don't think the issue is affirmation versus notary. It's just I think it's going to be making sure that we don't open up something to abuse on the other side by bad actors, not victims.
And I think we are definitely open to working to get some type of verification of identity or something like that written in there.
Yeah.
And I'm definitely open to that, Mr. Chairman. We have some other people here who want to testify on,
Let's go
on
ahead
behalf
and-
of this bill that came up here just today to do that. So can
Sure.
I
No,
allow
absolutely.
them to come to the table
Absolutely.
as we
Absolutely.
continue this
Yes.
discussion?
Absolutely. So let's go ahead and.
If I could,
Sure.
I have only one more thing that I do want to make sure I cover, and then I will let other folks have some time up here. As we're thinking about how to do this, I just want to make sure that we are aware that a victim ever having to find and pay for a private notary puts our state out of compliance with the Violence Against Women Act. And that's a federal law that basically requires any state that receives VAWA funding, which every state does, it requires that those states certify that their laws, policies, and practices don't cause victims to bear any cost associated with filing, issuing, modifying, serving a protective order. And so our state receives over $5 million every year in VAWA funding. And this notarization requirement, whether it's in law or in policy or in practice. So right now it's just in practice that they're sometimes having to go find and pay for a notary. That is a cost associated with filing a protective order for a victim. And so that does place our state at risk of losing that funding. And so really the only way to make sure that our laws, policies, and practices don't result in victims bearing the cost associated with notarization is to remove that notarization requirement. So.
Sure. Thank you.
Thanks.
All right, let's see here from others. All right.
I know
Oh,
Kim Sport with
Wait,
the.
sorry, Representative Seaball.
Thank you. Before you run away, I do want to thank you for bringing this, and I completely agree with you on the affirmation versus the affidavit. I'm with you 100% on that one. And again, having it notarized, having a notary sign off on it or stamp it doesn't, in my opinion, I don't think it adds any credibility to the allegations. It just merely says that you are the person who signed it, which I think is the only issue that I've heard here today that anybody has with the bill, is trying to make sure that we don't open up something that could be abused. I just have a question that came. Can this be mailed in, or does it have to be filed in person? Because some petitions can be mailed in. And if it can be mailed in, then there's no way to check an ID or to make sure it came from the person who actually sent it.
Right. I am also not a lawyer, although I'm less frequently.
You do a very
confused
good
for
impression of one.
I'm less frequently confused for once. So I don't want to answer that, and because I couldn't answer it correctly. And so I think that there are other folks who do it more frequently and have more experience with actually helping victims do the filing that might be able to answer that question better as to whether it's possible to mail in.
I do want to say I agree with Representative Marino on the penalty provision for the perjury. I think that's important. It also, what he said is correct. There's a stiffer penalty in Title 14. So I like the idea of cross-referencing that, because the curtailing the potential abuse is again, it's the only issue I think that I've heard anybody has with this. But if it's mailed in, you don't know who sent it, so you can't really prosecute for perjury somebody if you don't know who sent it in. So I would suggest that we try to find some way to verify that, or have some way of verifying who actually filed it or sent it in.
We're completely open to that, and I also want to make sure you all know that we were sure to keep the perjury in there, right? Because we have the same concerns, and we want to make sure that we're not doing anything that's going to end up harming victims in the long run. And so the current perjury wording that's in the bill that you all are looking at is the same as the Title 46 and the Children's Code ones. So that's where we pulled it from. But we're happy to reference the criminal statute on that.
Okay. All right. Thank you.
Thank you,
I don't have any
Representative
further
Seagull.
questions.
And I think the other thing is we want to make sure that, bringing up Representative Marino's question, is there a specific reason why this was the penalty when we adopted the law in the when we first adopted it? You know, like you referenced a lot of federal implications in a lot of this, so there may be a federal requirement in it. As why we originally placed it that way, or we can change it. So if we want to be able to cross-reference that and check before we make any changes, because you push one thing and you're out of compliance with the other, like you said with the notaries, and that's definitely something that I was not aware of. But you know, our clerk provides this service in St. Charles Parish and I believe in St. John Parish. But again, the law doesn't require it. It says only if available. So, okay. Here's for some more.
I think Kim
Wait.
Sport from the New Orleans
Yes.
Family and Justice Center.
Okay. And Representative Larverdane had a question.
Thank you, Mr. Chair. I think it's a good bill. I think with Rep. Marino and Rep. Seabar, we can find a way to tweak it to get it to what we feel comfortable with. My concern is that I'm in Rapides Parish, Alexandria area. When our clerk of court will do the notarization, do the paperwork, and then once the defendant is served, that defendant has to leave that presence, and we normally have a court date within a week by 2 weeks in Rapides, because in Rapides we do restraining orders every Friday, and so I think this is a good idea, bill. But once we tweak it, I think we can get in a posture, because, like everybody said, affidavit affirmation is still hurting and fighting and beating and choking. We want to make sure that we address those issues, and we want to make sure that we do not abuse it. That's our concern. But we do feel for the victims of domestic violence, we want to correct those issues. But I'm fully working with you with Ms. Freeman on this bill. Thank you.
Thank you, Representative Larding.
Thank you, Representative Larverdane. Representative Jefferson.
I agree with everything. Just want to throw this out there. There are individuals who are trying to, seek these TROs and what have you. They've left everything, so they have no verification. They left their driver's license, et cetera, wherever they came from. So as you are going through, just remember that, maybe we should be able to come up with something. But I've known instances where they just dropped everything and got the heck out of there. So let's be cognizant of that as well. Thank you, Mr. Chairman.
Representative Eccles for a question.
Thank you, Mr. Chairman. I just wanted to, at the appropriate time, move favorable on this with the expectation that Representative Freeman will work with Representative Muscarello, Marino, and everyone else to bring some amendments and clean it up going to the floor. But I want to thank you for your opportunity to bring this bill.
Well, I thank you for that. And I think we'll be able to get to that point. But we've spoken with Representative Freeman about making sure we do our work here. And I think I gave her my commitment, and I think she gave her.
Yeah,
us.
and so the chairman and I had a discussion that I will voluntarily defer this bill, and then we'll come back next week and tweak it before committee next week. But I do have other people here.
Yes, and
to
that's one of the
testify, and
things I want to make sure that we
they don't have to come back next week.
We want to get this bill fully vetted and make sure we get everything. I don't want to try to do anything on the fly, and this is the first day of hearings, and we've got plenty more, and we want to be able to work with everybody to address everybody's concerns.
Chairman Miller.
I removed my favorable
Thank you.
recommendation.
Thank you.
But thank you, Representative
yeah,
Eccles.
thank you.
I'll take that next week.
Okay. And I want to make an announcement that Committee Room 2 is available for overflow, so that you'll be able to watch us from Committee Room 2 if you want to go over there. So
Just wanted to answer a question, Chairman.
Sure.
For Muscarello, TROs cannot be mailed in. You must bring them in person, or they can be submitted by an attorney. They cannot be mailed in. So that, I don't know. I think it was you.
That was
Seaball. Oh, I'm sorry.
Okay.
I
So,
couldn't remember.
and we'll-
But they're not accepted as mail-in. They have to be brought in person by the victim themselves or their attorney.
okay. Thank you. And Representative Larry Freeman for a question.
Thank you, Mr. Chairman. I've listened to all of the testimony, and I don't do this type of law, but my question is, it sounds like there's an issue with getting a notary. The notary is the problem, as I see it. Am I correct, Rep. Freeman?
Yes, I do think that's part. And the 3-step process.
Correct.
Yeah.
Now, would that process be alleviated if every clerk's office would notarize when they walked in? Would that solve the problem?
It would, but from what I understand from the advocates, that not every clerk's office is situated like that.
Well, yeah, I agree.
So
I agree.
it could solve
but
it.
I'm just looking for some alternative ways to fix the problem if ultimately we can't. And is one of the ways to be if every clerk's office did the notarization at the clerk's office, would that solve the problem for you in your bill?
I would love to have the advocates answer that, because it sounds like a solution, but I don't necessarily know if it fully addresses what they're working on. And Kim Sport is here, and I'll let you introduce yourself, and maybe she can speak a little bit more to that, because she's been working on these issues way longer than I have.
Yeah, good
Thank you,
morning.
Mr. Chairman.
Okay.
Thank you, Representative.
Chairman Miller and members of the Civil Law and Procedure Committee, my name is Kim Sport. I am testifying today as a board member of the Family Justice Center in Orleans Parish and as the past chair of the Louisiana Commission to Prevent Domestic Abuse, as the past chair of the United Way for Southeast Louisiana Public Policy Committee, which also formed United Against Domestic Abuse. Been working on domestic abuse issues for 8 years. This is my 8th session dealing in domestic abuse issues with my partner in crime, Charmaine Cassiope, who most of you know. In these past 8 years, we've changed over 150 provisions of law to help assist victims of domestic abuse. The bill today is an important one. Yes, it would be great if every courthouse had a notary, but you have to figure, when we first started this path, which was in 2014, there were courthouses who didn't even have a fax machine. They didn't have a means of electronically submitting a TRO or a protective order to the Louisiana Protective Order Registry. Every courthouse is different. And I know that, did you say, Representative Muscarello, you're in repeats? Tangipahoa, you were repeats. Yeah. I don't know how those courthouses operate, but I do know that if you go into the Civil District Court in Orleans Parish, you're in for quite an experience. It's not easy. But let me just read this statement into the record, and then I'd be happy to answer your questions. I do want to say that in addition to all of the advocates for victims of domestic abuse who are in support of this bill, that the bill is further supported by the Louisiana Protective Order Registry, known as LPOR, in the Judicial Administrative Office of Louisiana Supreme Court. So that's a nice endorsement there. This bill would simply change the law in ex parte petitions for a protective order, which is actually a petition for a TRO, until such time as the defendant has been served and heard at a contradictory hearing as to whether the protective order will be issued. So this TRO, which can be issued ex parte, we know that ex parte relief is very, very uncommon. I think I can think of only one other situation where you can get ex parte relief, and that's in a probate, certain probate cases. But this TRO does not trigger any of the major repercussions that so many people who may have problems with this bill are worried about. For instance, with a TRO, there is no dispossession of a firearm for the pendency of the TRO. You cannot get an immediate divorce with a TRO. It has no effect on spousal support. And you're not going to be able to get exemplary damages if you decide to bring a civil suit for domestic abuse based on a TRO. I don't think there are any due process issues at stake, because if the TRO is issued without notice, the matter shall be set within 21 days for a rule to show cause why the protective order itself should not be issued. Notice of the TRO and the hearing on the rule to show cause shall be given to the defendant by service of process as required by law within 24 hours of the issuance of the TRO. Now, the Domestic Abuse Assistance Act requires that a petition for a PO, which requests a TRO, contain an affidavit as to the veracity of the allegations. This is true also in current Code of Civil Procedure Article 3603. House Bill 55, the bill we're talking about right now, allows the facts to be verified by affirmation, but it does not take away the possibility that you could also file your TRO by verifying your allegations with a notary. So that's not being taken away. And it only applies in the Code of Civil Procedure when the complainant is seeking protection from domestic abuse, dating violence, stalking, or sexual assault, and it is under threat of perjury, punishable by a fine, or imprisonment at hard labor. And I appreciate what Representative Marino was saying. This is language taken from the Domestic Abuse Assistance Act, and I did not write that act. But I do believe that it would be better to have all of the references to perjury conform to the Criminal Code Statute 14123. So, and there's one other thing I want to say. I don't know of very many other statutes where someone is complaining of being abused, where you always have the victim being told in writing, by the way, if this is a false accusation or allegation on your part, you're subject to perjury. Think about that. Why is it for victims of domestic abuse? Okay, so why is this rule necessary? Current law provides that a complainant shall not be required to prepay or be cast with court costs or cost of service of subpoena for the issuance or the dissolution of a TRO, a PO, or a preliminary or temporary injunction. As Mariah mentioned, this is part of what is required for us to get much necessary federal funding under the Violence Against Women Act. The clerk of court shall immediately and process the order regardless of the ability of the plaintiff to pay court costs. And this article also provides that the clerk of court in handling these very serious cases of domestic abuse, stalking, dating partner violence, and sexual assault shall provide all forms and clerical services, including the assistance of a notary, and again, where available for completion for the partition. Not the partition. I have another bill on partition tomorrow for completion of the petition. As I said before, many courts do not have notarial services. Orleans Parish right now does not have notarial services. So victims are forced to seek these services, which they will have to pay for at the most dangerous point in their lives, when they are finally taking steps to separate themselves from an abuser, a rapist, or a stalker. Everyone knows, everyone knows that separation from abuser is when you have the highest risk of homicide in a domestic violence situation. And as I mentioned before, going into any courthouse is in and of itself intimidating. It can be intimidating for attorneys, but think of what it's like for someone who is a victim. Having to navigate this complicated process is tough enough and is devastating to a victim who must leave a courthouse without any protection whatsoever due to the lack of a notarized signature, and walk around, try to find a notary on your own, pay for it when you might not, as Representative Jefferson said, have any ID or any money whatsoever when you think someone may be following you. We can do better for these terrified victims by simply requiring an affirmation that the allegations are true. And I want to close by saying that I became involved in domestic violence 8 years ago when I found out that one of my younger sisters had been living in a very abusive marriage for 12 years. And even though she lived in the exact same neighborhood as me, she never told me. She never told me until the day she left. So I believe victims. I believe that they're not going to take advantage of a process that allows for an affirmation in lieu of a notarized document. And I hope that you will support this bill, and I hope that it's not deferred. I really hope that it's not deferred. I think that the fixes are not so serious that they cannot be done between now and before this bill gets to the House floor. Thank you.
Thank you, Representative Carter. Wilfred Carter for a question.
Thank you, Mr. Chairman. Seems like we're making more of this bill than it is to me. It's just simply eliminating the requirement to get an affidavit signed by a notary. That's all it's doing. You're still going to have all the same legal requirements to making an affirmative statement to the clerk, whoever you go to apply for the protection. You still got to have a hearing in a certain period of time. The judge can still do some very serious punishment to you, to include contempt and other, find you guilty of perjury if you lie. So there are going to be some people that's going to take advantage like they're doing right now. Very few of them. But most women or individuals that are abused need help, and they need relief in a hurry. And most of them are really not thinking about what we think they're thinking about. They're only thinking about getting away and trying to get some protection. So I think we're making too much of this bill. I don't know why we just can't pass the bill. If somebody wants some particular language in it, they can do it between here and the House floor. But I move to pass the bill. And you can take it, I guess, if you want to, but I think it ought to pass. I think we're making it too complicated.
Thank you, Representative Carter. Look, I appreciate everybody wanting to get this bill out. This is the first day we've had a hearing, and I would hope that the committee would respect the committee process, and if there are fixes that need to be made, if they don't, we come back next week and we're going to have it's going to fly out of here. But I appreciate Ms. Sport, but also, I want to be able to make sure that we properly vet. We came in yesterday. This bill has had some concerns, not the main issue of the bill, but I hope we can get that worked out. And I made my commitment to Representative Freeman, and she made that commitment to me. But I want to make sure that we have everybody heard. And this, I don't think you're going to have any problems with this, but I do want to make sure that we properly use the committee process.
Okay.
Thank you.
Thank you, Chairman Miller.
Representative Nelson.
At risk of belaboring the point, have you ever heard of anyone having a problem with somebody impersonating somebody in order to get a temporary restraining order in these situations? So that's really all we're talking about, right? Because that's all the notary does is say this is the person. So if nobody is aware of anyone ever happening, it seems to me that the notary requirement is unnecessary, even to say that we could force every court or every clerk of court to notarize it, but we're already saying that it's not a problem, so why do we even waste the resources, right?
Correct.
So that's my
yeah.
look,
I don't think as anybody really the issue. I don't think is that between the affirmation and the notary. So, but thank you, Representative Nelson. All right, I think we want to hear from several others.
I don't know who else was behind me that was here, but I did know Kim was sitting behind me, and I don't know if Charmaine.
Sure, we have Morgan Lamondre with wishing to speak, Kathy Williams, Jacqueline Howard, Katie Hunter Lowry, and Richard Ducote. So,
all right, I don't know.
Good morning. My name's Morgan Lamondre from Star, and I'll just make a quick couple of points from some of the things that people have said. I checked with our East Baton Rouge clerk's office. They provide notary services. They have never checked IDs, and it's because of the dynamics of the situation. Most people are coming in without any proof of anything that they have. It's not a problem. They're not coming in saying there's somebody else. And in fact, nobody's checked my ID today. I sweared and affirmed that I'm here and telling the truth, but nobody's checked to make sure I'm who I am. I know people have heard of me and all, and there's a way to prove, but the point is nobody's checking everyone's ID that comes here. And then the part that I think Representative Freeman said about, would a possible solution be to just mandate that all of the clerks actually provide the notary services? That would be a solution. The problem that we'll end up seeing in victim advocacy world is we'll mandate things, but we find out after the fact, right? It's just going to be one clerk's office that doesn't have that person on staff on a particular day that they say, oh, this is the person who has the ability to notarize something. And then a victim goes, tries to file this, and then that person's not there, and they're like, oh, well, go somewhere to get this notarized, you have to pay, and we're already out of compliance. It's always like those little things that it happens here and there. This would just prevent that from happening, but that would be nice. I think if you all just take a look at some of the clerk's office websites, a lot of them have wrong information already on their websites that say, well, we don't do that here. You need to go to the DV program in order to file a restraining order, which just isn't true, and it's not supposed to happen. If a survivor, we obviously want them to have advocates, but if they can't, it shouldn't be that they're required to go to another place. And if they don't have access to the website prior, they're usually going to the clerk's office, being told, no, you got to go to the DV place. Then the DV place maybe helping them with the forms, and then they're sent back to the clerk's office. That's where we're trying to get rid of some of that burden. And then to the point about the mail, that just practically doesn't happen. Usually when survivors are trying to obtain this protection, it's immediate. I know there's just no situation where I've seen like a survivor really needed this and thought, oh, let me mail this in because of the time it takes. So I know Representative Marcel said something about it's not accepted. I've never seen a situation where a protection order like that would even practically happen. And then I think those were all of the points that I just wanted to make, but I'm happy to answer any questions. I do represent survivors in protective order proceedings, and I will say, in my experience, because we cover central and southeast Louisiana parishes, it is a bigger issue in the more rural areas. We had a survivor, it was like last summer, I think it was either Vernon Parish or Avoyles. There was no one there, and our legal program is based in Baton Rouge, so we had to get an attorney in the middle of the pandemic to drive to our Alexandria office to perform the notary services. So, I mean, this is a barrier for survivors, and we could have assisted with that petition, helped the survivor, emailed the survivor the petition, and she could have printed it up and then gone to the clerk's office and filed on her own, but then we had to spend resources for our attorney to get to the Alexandria area or Avoyles. I don't remember which one it was exactly. But anyway, that's all I have for you.
Thank you very much. We also have Kathy Williams with Oasis, a safe haven, would like to speak.
Good morning, and thank you. My name is Kathy Williams, and I'm the Executive Director of Oasis, a safe haven in Lake Charles in Calcasieu Parish, and I can tell you how things happen there. If you come to our office for a protective or for a temporary restraining order, I have 2 legal advocates, and they help you fill out the paperwork. One of them is a notary, and she will notarize it. Then you take it to the clerk's office for filing and get your court date. We also contract with an attorney who represents that person in court when they go for the protective order. If you don't come to our office, you go to the clerk's office, they literally hand you the paperwork and tell you to come back when you finish filling it out. They don't help you fill it out. They refuse to notarize it. They have been this way for years. And you also don't have an attorney to represent you. But that's just kind of besides the point. My own daughter was beaten severely, her face thrown against a car in the parking lot going to the clerk's office. It is very dangerous going back and forth. So anything we can do to streamline this and make it safer for victims, we definitely need. It's an ongoing issue for victims. I too am a survivor of domestic violence and went through a lot years ago to get a protective order. So we try our best to help as much as possible. But if my legal advocate that is a notary happens to be on vacation, out sick, anything like that, then you get to go look for a notary. And at that time, you're paying like $20 to get it notarized. And like one of the representatives said, you leave without an ID a lot of times. You leave with no money. Basically, what you have, you've got to be safe with. So to have to pay for that should not ever happen.
Thank you very much, Ms. Williams, for being here and sharing that. It's good to get the boots on the ground perspective of that. Thank you.
Thank you. We appreciate it.
Sure. Also, Jacqueline Howard. And then after that will be Katie Hunter Lowry and then Richard Ducote. Good morning.
Good morning, everyone. My name is Jacqueline Howard. I am a domestic violence advocate working at the Orleans Civil District Court for the New Orleans Family Justice Center. Like many people working in domestic violence, it has touched my family as well. I lost a cousin here in Baton Rouge in a murder-suicide several years ago, and I had a sister who had to flee New Orleans to get away from her abuser. Domestic violence is real. People are getting killed, men and women. And the part that we have to realize is we need to make it easier for those who are able and brave enough to take a stance and try to flee. Coming to get a temporary restraining order is not easy. And sometimes it's not even the best practice for someone because it could create a more dangerous situation. However, for those who are able and willing to come and get a temporary restraining order, we should make it as easy as possible. Now, at Civil District Court, I work with petitioners, and on occasion, I have an occasion to work with the abuser. I can't refuse service to anyone who comes before my desk, so there are times I hear both sides of the story. So I know someone may not be telling the truth. However, they both go before a notary, and they both get their petition signed, and they both file with the courts. So that is something on occasion that does happen. But we have to realize we have to remove the barriers for those who are trying to get temporary restraining orders, who are trying to flee situations, and this may be a temporary restraining order, may be part of their safety plan. Now, I am on the ground working with survivors. They come and sit before me day in and day out, and I hear their stories. If I'm sitting before someone with a busted lip, like just last week, or a black eye, if they're there to get a restraining order and there is no notary present, then they're left to go and find one. If there's no volunteer attorney or notary who can notarize that document for them, they're left to pay and bear the cost of it. Sometimes they leave with no phone because the abuser has it. They may not have identification because the abuser has taken their purse or just kicked them out the house. So there are several barriers that these survivors face. If we can remove the barrier, we can save lives. The number of people who may come in and be untruthful before me or untruthful before a notary, the judge will take testimony and then make that decision who's telling the truth and who's not. The truth factor is not eliminated because someone says, here's my ID, yes, I'm telling the truth, or this is me, this is my identity. That has nothing to do with the truth factor. Removing the barrier, removing the obstacles, helping these people get over the hurdles to save themselves or their children is what we need to do. Survivors bearing the cost of a notary, as you heard, puts the state out of compliance where we can lose funding. We definitely don't want that. But more importantly, we do want to save lives.
Thank you, Ms. Howard, and you again are somebody who's been touched, so closely by loss of family members, and this has been a big impact. And of course, we know the statistics, and I think that there's no doubt that we'll be removing those barriers. So,
and one more thing I want to add, as far as verifying identity, that's something that the clerk's office can do when the person goes to file. All they would have to do is present the temporary restraining order packet along with identification and say, yeah, this is me, I'm submitting this document. Easy fix.
Yeah. Okay. Thank you. All right. Next, Katie Hunter Long.
Thank you. My handwriting must be especially bad today. My name is Katie Hunter Lowry.
Lowry, or maybe my eyesight is going bad. Lowry.
Thanks, y'all, so much. I want to affirm and thank all the survivors and victim survivors who have shared their story today. It's a difficult thing to do, so thank you so much, Representative Freeman. My name is Katie Hunter Lowry. I'm the crime survivor organizer with the Promise of Justice Initiative, and I organize the Louisiana Survivors for Reform Coalition. Many of the folks in our LSR community are healing from or actively surviving domestic abuse. The barriers that these survivors face to getting and staying safe, having their support to recover, and the barriers they face to be heard by decision makers and gatekeepers of the criminal legal system are countless. I wish Representative Carter was here because I really want to lift up that the recentering of the abuse that we're talking about. It's not the abuse that we're here to address is not fraudulent filing of an application. It's some of the things that Representative Laverdane referred to. It's beating, it's choking, it's the homicide. And it is difficult as a survivor to listen to the centering be around a filing process and not the very, very real difficulties that victims of domestic abuse face. So LSR strongly supports Representative Freeman's bill to remove these bureaucratic hurdles. Compounding financial costs, even small ones, harm survivors, and cash is the number one most urgent need to get and stay safe during COVID for domestic violence victims. For those of us recovering from or trying to escape abuse, the precious time, emotional energy, and skills needed to navigate bureaucracy often make getting help just impossible and inaccessible. This bill is a great step in recognizing that it's necessary to dismantle these barriers, as so many of the victim advocates have said today, and it is a part of the task. It's a first step. We have to listen to and believe directly impacted people, and we need to fund culturally competent, trauma-informed services, invest in crime prevention and restorative approaches. Restraining orders and reliance on law enforcement alone is not going to stop interpersonal violence or offer healing to those of us who need it. And we ask that this committee support HB 55 and use this as a stepping stone to dismantling more barriers and as a pathway to more complete services.
Thank you, Ms. Hunter. Lowry. Appreciate you being here. And finally, we have Richard Ducote.
Good morning. My name is Richard Ducote. I'm an attorney in Covington. I've been practicing law for 43 years. The vast majority has been involved on behalf of victims of child abuse and domestic violence. I came to testify specifically to the point Representative Marino made, and I do have a fix for that. The problem is these three provisions all define perjury inconsistently with the criminal code, and also this definition should not be here because it's already in the criminal code. So my suggestion would be to remove the following sentence in each provision, the one that says any false statement contained in the petition shall constitute perjury, to where it ends at both. Just strike that, put comma after the sentence that ends before that, and just add subject to prosecution for perjury under RS 14:123. Perjury requires intent, and it has to be material, as Representative Marino pointed out, and I think that would solve the problem. I'm also a member of the Pennsylvania Bar, where notaries are not used for any of this. Every pleading in Pennsylvania that has any allegations of fact has to be verified, and the verification simply says, I verify all this to be true, and if I'm lying, I can be prosecuted. And it's not a problem. Regarding Representative Muscarello and Representative Freeman, you're absolutely right. Every clerk of court, every deputy clerk of court is an ex officio notary public. The reason that it's not done as it should be done is because, and we've heard the term notary services, they don't want to be giving out notary services. They believe there's a slippery slope, because then everybody who's going to want something notarized is going to come to the clerk of court and expect notary services. And I think the way to do that is to simply mandate that every clerk of court has to provide the service of notarizing this particular petition if requested, and that would solve the problem. Some of them do, some of them don't, and it's just they don't want to. That's not my job. That's how they view it. So.
Thank you, Mr. Ducote. All right. I think that's everybody.
Thanks.
Appreciate another practitioner's point of view on this. We also have a white card and would like to speak from Debbie Hudnall with the Clerk of Courts Association. And Ms. Hudnall, I think we might have a couple of questions.
Okay, thank you. Good morning. I'm Debbie
Good morning.
Hudnall. I'm the Executive Director of the Louisiana Clerks Association. I'm very familiar with the domestic violence. I was a clerk of court for 27 years, and I worked with the victims when they came into my office. This past year, I had to accompany my daughter to East Baton Rouge Parish Clerk's Office to file for domestic violence, so I'm very familiar with this. I wasn't aware that there was an issue with the clerk's office until I received a call this morning from Representative Freeman, and she told me that there were some clerk's offices that were not notarizing these documents. As a previous witness said, every deputy clerk is an ex officio notary. And I did not know that there was an issue with any office not doing this. When I talked to Representative Freeman this morning, she gave me 3 parishes, and on my way to the Capitol, I contacted those 3 parishes, Orleans being one. Orleans said, I talked to the Clerk of Court, Chelsea Napoleon, and she said that their pro bono office had always handled domestic violence cases and where they would be notarized, but during the pandemic, they didn't have their offices open. So Chelsea Napoleon told me that 2 months ago that her office clerk's office had started notarizing the documents and that they would be notarizing those in the future. The other parish they gave me was Ouachita Parish, and she told the clerk there told me that normally that the petitions were filed with the DA's office because the DA's office gets grants to handle domestic violence. But she said that they normally notarize them, but she said that there has been occasion where they came in. She is a new clerk. She said it has been a practice in the past that they didn't notarize, but she said if we have the authority to notarize, we will notarize those. The other parish they gave me was Calcasieu. I talked to the clerk's office in Calcasieu this morning, and they said they had not been notarizing them, but if that was something they are supposed to do, that they would. I've been executive director for 14 years. I was a clerk for 27 years. Had anyone call me to say that there was an issue, I would have gladly reached out to those offices. We have no problem with this bill. But if there's any other parishes that the clerks are not notarizing this, if you give me those parishes before I leave this morning, I will be in touch with them and they will begin notarizing them. I have a good rapport with the clerks and they know that I'm going to give them the correct information. I'll be happy to answer any questions you have.
Thank you. And of course, that only is part of the issue why they're bringing the bill. You know, even having to go, kind of can create yet another extra burden on them, and I think that's what we're trying to accomplish in this legislation.
Certainly, and we have no problem with it. In many parishes, because the victims are looking for a place to stay, they go to the domestic violence place, and I think a lot of times there they have forms there, and they help the victims there. And then once those documents are brought into the clerk's office, then certainly they should be notarizing them.
Thank you. Okay, I think that's all the questions. I'm going to just go ahead and read in all the cards. I think we've heard from everybody, but we had green cards in support. Did speak Mariah Wineski, Louisiana Coalition Against Domestic Violence. Kim Sport, New Orleans Family Justice Center, president, and in support, and she did speak. Morgan Lamondre from the Sexual Trauma Awareness and Response president and did speak in support. Kathy Williams, Oasis, a Safe Haven. Jacqueline G. Howard, New Orleans Family Justice Center, in support. Katie Hunter Lowry, Louisiana Survivors for Reform, in support, and Richard Ducote. And green cards, supporting but not wishing to speak, Charmaine Cassiope for United Way, Southeast Louisiana. Green card, present and in support, Latasha Davis, LCADV, not wishing to speak. Green card in support, not wishing to speak, Susan East Nelson, Louisiana Partnership for Children and Families, and not wishing to speak, President in support, Peter Robbins Brown, Louisiana Progress. Representative, and of course we have the white card, President who would like to speak, Debbie Hudnall from the Clerks Courts Association. Representative Freeman, go ahead.
Sure. Thank you, Chairman Miller, and thank you to all the advocates who came and supporters to speak about this bill. I will voluntarily defer the bill till next week, and we can work on some of these issues and get the bill in its proper form.
You prefer a Monday or a Tuesday?
I'll do Monday.
Okay.
I'll go
right.
first.
And we'll get right on trying to address any little tweaks that we have to, so we can get this bill to the floor. It can be on the floor next week.
Okay. Thank you so much, Chairman Miller, and thank
All
you
right.
to the committee members.
All right. Thank you.